process leading up to its passage?
No, but I think that the court has to look at all of that. In the context, what the court has said, you have to look at the context in which the measure was passed. Now, I will say, if I move to that point, this concept of rational procreation, there is no way that Proposition 8 prevents, by keeping individuals of the same sex from getting married, have anything to do with heterosexual marriage. Same-sex marriage is not going to discourage heterosexual people from getting married. It is not going to keep them from getting divorced. It is not going to have any effect at all on their choice about having children. On the other hand, the elimination of Proposition 8 cannot possibly hurt the heterosexual relationship at all. In this case, the evidence was clear from the witnesses in this case that there would be no harm as a result of the elimination of Proposition 8. And Mr. Cooper, quite candidly, when he was asked that question at the summary judgment hearing, repeatedly by the district court, what harm can there be? He said, I don't know. Now, what he meant, and I'll let him speak for himself on this, but what he was saying is that we don't know the impact of allowing same-sex marriage and how it might affect this very important institution of marriage. Well, it's a very important institution of marriage because it means a great deal to the citizens of this state.
You know, people in popular election campaigns make all sort of nonsensical arguments.
I haven't heard that.
Not to vote for someone or to vote for someone. But you know, my point is this, that my reading of these cases suggests that this is a matter of what is referred to as legislative facts, that it really matters not what a whole bunch of people might suggest one way or another. This is a sort of a legislative fact thing that we look to. And if we can conceive, it can be conceived and argued that there's a rational basis to uphold the constitutionality of Prop 8, that satisfies the test.
Well, I will have several answers to that. One, this idea of legislative facts means that instead of the witnesses that talked about the history of discrimination, the damage that discrimination has done, the immutable characteristic that we're talking about, people don't choose to become gay. They have a characteristic which this court and in the Hernandez case and the California Supreme Court has talked about. And with respect to the immutability, if I can have a slight digression, is that all of the plaintiffs and other witnesses in this case and the experts and the judge's findings suggested that this is a characteristic that's immutable. And we have all of those reasons why, and the long history of discrimination, which Mr. Cooper stipulated to at the trial, the damage that's done as a result of the discrimination, all of this requires heightened scrutiny. But if you were to go to an imagined, at a rational basis standard articulated along the lines that you did, which I don't think is the test. I don't think that's at all consistent with City of Claiborne, and it's not consistent with Romer at all. But if you were to say that, what can we imagine? What conceivable thing can we think of that would justify doing the damage that's being done to our citizens in California? What is it? I don't know what it is. It can't
Well, just a minute. Maybe I could suggest a couple of things. Do you believe that the idea of distinguishing marriage from domestic partnerships in name only in order to promote it as a vehicle for procreation, responsible procreation, an inclusion of one group promotes legitimate government purpose, all things being equal, children are most likely to thrive when raised by father and mother who brought them into this world? Do you believe that that would survive rational basis review?
It would be slightly inconsistent with the evidence in this case, number one. Number two,
Well, it's slightly inconsistent with the evidence in this case if you naturally jump to the conclusion that the only evidence in this case is that which the judge has suggested is in the record, rather than that legislatures do things for their own reasons and then the judge might find if there's evidence for it or against it. But I'm suggesting, now just sit the question, the idea of distinguishing marriage from domestic partnerships in name only to promote it as a vehicle for procreation, all else being equal, children likely to thrive when raised by father and mother who brought them into this world, that it is rational.
Yes. In the first place, Mr. Cooper specifically said just a few moments ago, the name is the institution. Those are his words, virtually verbatim. The name is the institution, and the witnesses at this trial, the witnesses that came forward and were willing to be cross-examined and were willing to testify under oath, not the law review articles and so forth that were put in by the proponents, but the witnesses that came forward in this case, and the plaintiffs and other witnesses in this case, talked about what marriage meant to them and what it means in this society as an institution. Not just what the Supreme Court said, but we had what the plaintiffs said, what the experts said, what the Supreme Court said, and what the district court found. And there's nothing that would suggest that children thrive in a better way in that environment. In fact, the proponent's expert, Mr. Blankenhorn, testified that the children in those relationships would be better off, that we would be a better country, we would be closer to the American ideal if same-sex marriage were permitted. Now, it's easy to say those things, that you have to have you have a better situation where a child is in with a mother and a father, but allowing the other problem with that is that the remedy doesn't fit the so-called problem. In other words, restricting marriage to people of opposite sex doesn't mean that there won't be people in same-sex marriages. That California permits that, and the court, there's something like 37,000 children in same-sex households in California today. There are also 18,000 same-sex marriages which are not at issue in this case. It's easy to say that children would be better off in that relationship, but if you have heterosexual relationships permitted in California and marriages between persons of the same sex, it doesn't change where the children will be raised. If a child is a product of a biological relationship between a man and a woman, that's up to that man and that woman to keep them together. I think Judge Reinhardt suggested that a better remedy for that would be prohibit divorce, but that's not something that Californians are interested in doing.
Are we free to use anything other than the rational basis test in the Ninth Circuit?
Oh yes, I believe very strongly that you are. The Hernandez case talks about immutability. To the extent that you're referring to any other aspect of the doctrine of heightened standard, I think that it's been ventilated, and the issues that would support an enhanced heightened scrutiny are all present, and you would be bound by what the Supreme Court has said with respect to that.
How about our Witt case?
I think the Witt case supports exactly what I was just saying.
The factual circumstance, you argue factual circumstances are different in Witt and high-tech gays, but I guess, do you have authority that the factual circumstances alone would allow us to make a different holding than a prior three-judge panel?
I think that the Hernandez case, which is a subsequent decision, already addresses that issue, and I think the case that Judge Reinhardt focused on involving the federal public defender, I think it was Levinson, also addressed that point.
Well, it wasn't the case, unfortunately, but it was an administrative ruling.
Well, I thought the wisdom in that case was superb. And the reasoning, I think, in that I couldn't do a better job in answering the earlier question than the reasoning set forth in writing in that case. And with respect to the Baker case, the Supreme Court has made it very clear that when the facts are different and the precise issue is not the same, Sexual orientation was not presented in that case. That was strictly a gender case, not a sexual orientation case. The facts here are different, not just the Romer situation where California has recognized same-sex marriages and then has taken it away, but California has an interesting crazy quilt system of laws in this state with respect to marriage. Some people may be married because they're heterosexual, and some people may not be married because they wish to marry someone of the same sex. Some people who were married to someone of the same sex may stay married, but if they were to get a divorce, they couldn't even remarry the same person. And some persons that are out of state, and if their marriage is legal outside the state, then they are recognized in California. We have an irrational system here. And finally, with respect to the Baker case, the doctrinal ground has changed because of the Supreme Court's sex discrimination cases, and it's changed with respect to the Romer case, and it's changed with respect to Lawrence versus Texas. What this case comes down to, it seems to me, that California has built a fence around its gay and lesbian citizens, and it's built a fence around the institution of marriage, which the Supreme Court says, not based upon sex or procreation or anything else, is the most important relation in life. And the citizens of California, within that one fence, because of their sexual orientation, are denied access to what every other citizen in California has that are enclosed within that other fence. That is a violation of the Equal Protection Clause, and it's a violation of the Due Process Clause.
Are we free, in view of the way the Supreme Court has told us, to decide constitutional issues, that the broadest should be avoided, the narrowest should be adopted? Are we free to do anything other than decide the issue of whether California's repeal of an initiative constitutes a violation? Your closing speech would require a holding that any state that did not permit gay marriage would be in violation of the Constitution. There is a possibility, I think, in this case, of saying that Proposition 8's withdrawal of the right of gay marriage from gays and lesbians is unconstitutional under the circumstances that they enjoyed that right, that they are given every other aspect of marriage, and all that is taken away is the honorific designation. Are we free to go beyond a holding, if we were to rule in your favor, a holding that the repeal of the right to marriage, the right to use the label marriage and to receive a certificate, that under those circumstances it's a violation? Can we, in view of Plout and similar cases, go farther than that?
I don't think, by the way, you mentioned that I was involved in that case. I don't think that case in any way should inhibit you from doing what I think is I think the answer to your question is that you could decide this on the narrow ground that the Romer case gives to you, put in conjunction with in re marriage from the California Supreme Court. But I think this case I don't think there's anything in the United States Supreme Court jurisprudence, including the Prout case or anything else, that suggests that you can't look at the larger the constitutional question, which that earlier question is subsumed within. What has California done? California has taken a class of citizens and put them in a separate category, whether they had a different category before or not. And that act of discrimination, there's no doubt that it is discrimination. And there's no doubt that it does great harm. The only question is, can it be justified under any standard of constitutional analysis? And I submit that it cannot be justified under any standard of constitutional analysis, because at the lowest standard, rational basis, you'd have to know what is rational. And all of the arguments that my opponent is making with respect to how valuable the institution of marriage is are not rational when it comes to the reason of the question of, well, why did you draw that line? heterosexual people are different than homosexual people. Gays and lesbians are different than straight people, to use the vernacular. But that does not mean you can classify them